record, my name is Lou Borey, and I'm here to testify about the road rule, committee's request, and just a little bit about my background as it relates to the road rule. I worked for the Active 50 program for almost 30 years, and dealt with the road rule directly for part of that time. I was the district coordinator for Active 50 in Chittenden County, District 4, for 10 years, starting in 1988. And in that role, I was the administrator for Active 50 in Chittenden County. I worked essentially as a staff person for the district commission, which heard and decided on Active 50 applications. I also issued jurisdictional opinions about the applicability of Active 50, including rules like the road rule. So I issued jurisdictional opinions about the road rule. And then in 1997, I was appointed as the chief coordinator for the environmental board at that time. And in that role, I supervised and provided training to all the district coordinators around the state. So again, I worked directly with Active 50 jurisdictional issues and other issues related to how Active 50 was administered at the district level. And then in 2008, I was appointed as the executive director of the Resources Board, the successor to the environmental board, and served in that capacity until 2016. And during that time, I was responsible for the overall administration of Active 50 under the direction of the chair of the Natural Resources Board. So that's my background, and sort of that's what I'll be drawing on in terms of my comments, but primarily really drawing on my experience as a district coordinator, because that's when I worked directly on a day-to-day basis with jurisdictional issues like whether or not the road rule applies to a particular project.
Representative Forgates has a question.
Can you explain to me what the road rule is? Because I don't know.
That's what I'm about to do.
Okay, fine.
So I just was trying to set the stage a little bit.
Yeah.
I should also note that I'm speaking really on behalf of myself. I was contacted by Greg Vogel, the Board of General Counsel, about whether I could offer some comments. I'm happy to do that, but this really is, I'm not speaking directly on behalf of the Natural Resources Board today. So at the outset, I'll just say that the road rule, which I will describe, and it's part of my written testimony, so coming up on the screen at some point. I was never a particular fan of the road rule. It was part of Active 50 really from almost the outset. It first became part of the law in 1975. So it was part of the law almost from the beginning. Oh, okay. So I'll so anyway, I was my sort of initial message is that the road rule was a little bit difficult to apply, create some confusion. It did achieve, I think, part of the goal of regulating small rural subdivisions, but there were some issues with applying it that eventually led to its repeal in 2001. So that said, I think that there may be some concepts that were in the road rule, and some parts of the road rule that could be reapplied or applied in situations where it's important to try to regulate small rural subdivisions in areas where there are sensitive natural resources. But I think the road rule as it stood had some issues, and I'll try to describe those. So the road rule, as I said, first became part of Active 50 in 1975. It was part of the Active 50 rules, which at the time were called the Environmental Board Rules. The original language is, for reference purposes, you can see the original language, and then in number 3, the final language of the road rule when it was repealed in 2001. It went through several amendments during that, between 1975 and 2001, but The final version, which I believe is in your bill as sort of placeholder at the moment, is the version that you see in number 3. The sort of the two essential parts of the road rule were that if there was a road being constructed that was more than 800 feet in length, and it was going to serve a subdivision, and I'll get into more about what that means, then that required a permit. And not just the road itself, but the entire subdivision required a permit. Or if the road was to provide access to more than 5 parcels. So it could be any length, it could be 100 feet in length, but if it was to serve more than 5 parcels, it also required a permit. And there was a 2-year cumulative counting period or period when you could add together the length of the road in the initial version of the road rule. And then as it was amended over the years, you'll see in number 3 that some additional language was added. And the concept of 1 acre and 10 acre towns was added. I think you may be familiar with that, because it appears in Act 50 many times. So 1 acre towns without permanent zoning and subdivision, the road rule applied if the land being provided access to the road was more than 1 acre. In towns with permanent zoning and subdivision, which are 10 acre towns, it only applied if the tract of land being provided access by the road was more than 10 acres. And then the next sentence just clarified that for the purposes of determining jurisdiction, any parcel of land, so the entire subdivision would be subject to the jurisdiction, just because that wasn't in the initial version. And then the only other changes made was that the cumulative period was extended from 2 years to 10 years. So you can add up all portions of the roads constructed over 10 years when determining jurisdiction. So that's how the road rule appeared until 2001, and I'll go into more about when and how it was repealed in a minute. But the elements, which we sort of already talked about, the 1 acre and 10 acre distinction, similar to other jurisdictional triggers. All land served by the road subject to jurisdiction, not just the road itself, and then the 800-foot length or serving more than 5 parcels. It's important to point out that even though the road rule applied to subdivisions that were served by roads, it was never in the definition of subdivision. It's always in the definition of development. And so that meant that there had to be construction of some type associated with the road to trigger the road rule. Not subdivision of parcels was not what triggered the road rule. It was the construction of a road to serve those parcels. And that was part of the difficulty of applying it, was trying to figure out what was the road, when was the road built, was it driveway, how many lots did it serve, those kinds of things, which again I'll go into in a little more detail. But the fact that it was part of the definition of development and not subdivision created some issues. So effectively, the road rule regulated subdivisions of between 2 and 9 lots. So if you were just building a long driveway to serve 1 lot, that did not trigger the road rule. That was the driveway. But if you were building more than that, a right-of-way or a road that was more than 1 house, then that could potentially trigger the road rule. So the road rule was in effect until July 1, 2001, and it was repealed at that time pursuant to Act 40 of the 2001 legislative session, which was a permit reform bill, one of several permit reform bills which have been reviewed by the legislature over the years. It was based on a summer study committee that was looking at ways to improve Act 50 primary thrust of that bill was to set up a pilot program for on-the-record appeals. That was the title of the bill, I believe, but it did include a number of other changes or amendments to Act 50, one of which was to repeal the road rule. So in its place, or added to Act 50 at that time by Act 40, was an amendment to the definition of subdivision. And this is, as you know, is still part of the law. And this addition to the definition of subdivision provided that when someone is subdividing 6 or more lots in a 1 acre town, a town that doesn't have permanent zoning or subdivision, then that requires a permit. The typical, or the normal trigger, as you know, is 10 lots in any town in the law. But in 1 acre towns, when this provision was added, you needed a permit to subdivide 6 or more lots. So it lowered the lot threshold in 1 acre towns. And so it was, I wasn't involved at the time in terms of, you know, how the road rule was repealed, and how this provision was added, but my recollection is that this provision was added as sort of a quid pro quo in terms of trying to regulate smaller subdivisions in rural towns. I don't know that it achieved the exact, you know, same purpose as the road rule. It only applied to subdivisions of 6 or more lots, whereas the road rule could have applied to subdivisions as small as 2 lots. So it didn't capture that sort of 2 to 5 lot small subdivision category. But my recollection is that it was offered as kind of a replacement for the road rule at that time, and it's still part of the law. So what were the challenges, as I sort of remember them, of applying the road rule? The first challenge was trying to figure out what was a road. There was no definition of road, there ever has been in the statute. So it had to be defined by board ruling. There were a number of declaratory rulings, and actually the Supreme Court decisions as well, which helped to flesh out what exactly a road is. And essentially, road, the definition, according to those rulings, was that a road was a shared right-of-way serving 2 or more lots. So, again, driveway is not a road, it's just serving 1 lot. But as soon as that driveway or right-of-way became shared by more than 1 lot owner and was more than 800 feet in length, the shared portion was more than 800 feet in length, then that's when it turned into a road. It may have looked exactly the same, but as soon as it became shared for more than 800 feet, then that's what triggered at least the 800-foot provision of the road. The provision about serving more than 5 lots was a little bit more straightforward, because when you count the number of lots, it was actually being provided access, that were being provided access by the road at that point. But that was one of the first challenges, and it's still hard to determine sometimes whether or not something was a road or a driveway, or exactly what it was. How to measure the length of the road was sometimes an issue when it ended in a cul-de-sac or a hammerhead. You know, most of the time, oftentimes, the developer or the landowner was trying to maximize the length of the road without actually triggering the road rule. So they were trying to design around the road rule, which was, again, that was part of the challenge. So that was sometimes an issue, was exactly how to measure the length of the road. The cumulative length provision could be a challenge, because it required looking back 10 years, and there weren't always very good records in terms of trying to figure out how to add up the various portions of road or driveway, or driveways that became roads within the tract of land. So was also a challenge. The timing of road construction was sometimes an issue because there were times when, and there were several court cases about this, when a road was actually constructed for a non-subdivision purpose or even a non-residential purpose like lotting. And then subsequently, it started to serve more than a couple of lots. And so, even though there was no construction at the time, it had to be to trigger the road rule, the road then started serving more than 2 lots. And so then the question is, well, was it built for the subdivision? Was it built to serve lots, or was it built for another purpose? And then, over time, started to serve the subdivision. So trying to figure out the intent was could be a challenge. And again, there was some court cases about that kind of scenario. And then finally, as I mentioned, there were a number of environmental board territory rulings and Supreme Court cases which helped to flesh out the road rule, which was helpful in many respects, but they didn't always, weren't always very consistent. And so trying to apply the body of law to situations involving the road rule could be a challenge as well. And then in terms of some of the, as I perceived them, the negative aspects of the road rule, I felt that it often led to poor land use. It promoted poor land use because of the fact that developers and landlords were trying to, design the project to avoid the road rule. And so oftentimes you would have long driveways, parallel driveways sometimes, going off into the forest or into the field, specifically because they didn't want to share a driveway that would then trigger the road rule. So that was often the case. There were many 799-foot roads or 790-foot roads that would end in cul-de-sac, and then there would be 4 or 5 or 6 long driveways that would then split off from that. But under that scenario, it didn't trigger the road rule because the shared portion was still less than sometimes to avoid the triggering the number of lots, the 5 lot, or 6 lot trigger, more than 5 lots, the development would be served by, the road would serve 4 lots, and then the rest of the lots in subdivision would have driveways on the main road. So that added to curb cuts on the main roads, again, to limit the number of lots served by the actual subdivision road. So again, that was, I think, an example where the road rule, or avoiding the road rule, poor design, poor land use. So I think, again, overall, there was an attempt in many cases to avoid the road rule, but that didn't sometimes result in very well planned subdivision. So those are some of my observations. Happy to try to answer questions about how the road rule was applied. But I think that, again, if the purpose of the road rule was to try to regulate smaller rural subdivisions involving roads, there may be other ways to do that without using a trigger that is hard to apply and hard to lowering the lot threshold in areas where sensitive natural resources is one option. The 6 lot threshold was kind of went part of the way toward that, but there may be other ways to try to get at that. Long driveways, I think, are in many respects just as harmful as long roads. Driveways with utilities, and now that the driveway standards are more robust, a driveway today is really equivalent to what a road might have been back in the 70s and 80s. So long driveways in and of themselves, I think, have potential to create the kind of fragmentation that the road rule was intended to concept, but again, I think using the road, construction of a road was the wrong or a difficult way to achieve that.
Thank you very much. We have a few questions. Representative Lefebvre and then Forgetz.
Thank you. Thanks for the testimony. If I had a house, primary resident, at the end of an 800-foot road that I put in to build this house, say on a pasture or something, it's no longer pasture land, and I wanted to give 2 acres to my son, will that fall under Act 250 jurisdiction if the road rule was in play?
So originally,
Originally it's mine, yeah.
No jurisdiction.
Mhm. Correct.
But if you were then to subdivide another lot,
Yeah,
does that create jurisdiction?
that's correct.
I'm going to say no, it wouldn't trigger jurisdiction, only because, again, what triggered jurisdiction in the road rule was construction of the road. So if the road was already there and serving a certain number of lots, but not enough to trigger the road rule, and then another lot was subdivided, there's no nexus there between road construction and subdivision. Now, sometimes, we could kind of demonstrate that the intent all along, if the intention all along, if you could demonstrate that the intention all along was to subdivide those additional lots that would have triggered the road rule, but sort of keeping in their back pocket, then that's one scenario that could have triggered the road rule. But if it was just sort of a natural evolution of the subdivision and one more lot was developed, I don't believe that would trigger the road rule. But it brings up, I think, part of the challenge. It raises the question, what's the road rule intended to apply that situation or not?
One other question, what in your mind was lost by giving it up, by giving the rule up, as far as Act 255?
Well, I think there were cases where there were long roads constructed into sensitive environmental areas, natural resource areas that did trigger the road rule, and so that provided a review of that subdivision.
The sensitive areas alone didn't do that?
Well, there's no activity jurisdiction isn't that really based on the location in terms of sensitive natural resources. It's really based on plots, acreage, that kind of thing. So I think there were things lost, but I think as much there were a lot of subdivisions that were designed not to trigger the road rule, and so those things were lost.
So I have to ask you the corollary. In your opinion, would you like to see it brought back?
Not in its present form, or its form as it was in 2001.
Representative Forgetz.
Was it assumed that an 800-foot road was going to take 1 acre of land? Is that what brought up 800 foot? Or what?
I don't know. I really don't know what the origin of the 800-foot rule was. Whether it did sort of have some, trigger in terms of acreage. I don't know.
Representative McCullough.
So to follow up on Representative Lefebvre and your last question, your answer was not in that form as it was when it was done away with. Then is there a form that you might recommend? And the second part of that is, would you put that down for us and send it? Easy question.
I could try. I haven't spent any time quite trying to formulate a replacement, but I think it would need to include elements of long driveways and small subdivisions, because larger subdivisions are already taken care of. So it's really that small 2 to 5 lot subdivision trigger that I think, and maybe combined with construction of a long driveway.
And what would, that's helpful, thank you. So semantics sometimes are just semantics, but sometimes they're really important. Was ingress egress ever considered as a substitute for the word road? Because we're always wrestling, is it a driveway or is it a road? And we absolutely know what ingress egress means. And how might that play out in your mind?
I think that could be a substitute. I think as long as there's, if you did away with any distinction between driveway and road and didn't, try to, split hairs there, I think that would be probably the most helpful. Any kind of right of way serving residential lots is really about whether it's a single driveway or a shared driveway or an actual subdivision road.
Right. Thank you.
Representative Morgan.
Did this apply to abandoned roads or class 4 roads?
Did it?
Yes.
It did not unless those were being upgraded. And that was another challenge, was to figure out whether, what was there, whether it had the ability to serve a subdivision or whether it needed to be upgraded. There were several decisions which said that even though the developer wasn't planning to upgrade a class 4 road or a type of road to serve a subdivision, the useful, occupancy of homes in that subdivision would have required upgrading the road. And in that case, the decision was not to trigger the road because they had to upgrade the road.
Even though it was a pre-existing town road.
Any other questions? Thank you very much for coming.
You're welcome. It's helpful, and I should just say that there are others who are involved in Act 250 who probably have more experience with the road more than I do, so they may
Who are those
including
others?
one who's sitting right behind me.
Oh, Ed?
Yeah.
Great, yeah, we know Ed, we know how to get in touch with him.
Good. And I worked in Chittenden County for the first 10 years when I was applying the road rule, so Chittenden County in many ways is sort of an anomaly, and so perspective from other rural districts might be helpful. So.
Great, well, we're gonna have an opportunity for that, maybe in the next. Thank you.
You're welcome.
Thank you. For folks who are standing, we actually could grab a couple more chairs from the cafeteria. I think, I'm missing the table, or there's folding chairs, it's true. So you feel free to grab a folding chair and put a few more chairs on this board. We don't need two here for the witness either, so we get to pull this one back.
Just grab the wooden chairs.
Or we can, actually the folding chairs might be better because they're smaller.
Go by yourself. Pass that one down.
All right. William Burke.
One more.
No, I think we're done. Thank you. You can alternate.
I'm always here for fun. Just like, get to be.
Right.
Living the dream.
Call the meeting back to order.
When I'm about to
Welcome.
wake up.
Thanks for coming.
Good afternoon. My name is William Burke. It's been my privilege to serve as your Act 250 District Commissioner, District Coordinator for District 1 in Rutland County for 26 years. In that time, if I've learned nothing else, I've learned that Vermont has been blessed with a series of citizen volunteers, one of whom is Representative Terenzini's recently appointed Act 250 District Commission Chair, Joshua, new chair of my commission in Rutland.
I have to make a statement, he's a lot brighter than his father, so.
Well, that's what he said.
Wait, your son is a new commissioner?
Yeah.
Oh, great.
Good chair. Seems like a very nice gentleman.
He was raised well.
I've learned that Vermont has been blessed with a series of citizen volunteers, the Act 50 District Commissioners, who have dedicated themselves to the difficult task of evaluating each case on its merits, sometimes under difficult circumstances, and its citizens of the state of Vermont very much appreciate the opportunity to participate in the Act 250 process in front of these commissioners. Thank you so much for your invitation to share with you my experiences and concerns as you embark on the difficult task of addressing the next 50 years of Act 250. In my invitation to testify today, Representative Sheldon asked that I prepare to present about my experiences as the district coordinator in Rutland County for the natural resources. For the record, my remarks today are made as an active duty district coordinator, and my testimony is mine alone, and is not intended to represent any official policy or position of the NRF&W. I have two principal observations I'd like to share with you today. First, the fundamental integrity of the Act 250 process, and second, slate quarry exemption. And I do hope that you'll allow me to read my statement as portions of the required procedure. And I'll be happy to answer any questions you may have. First, the integrity of the process. It's always been my belief that my duty as an Act 250 district coordinator is to provide the best advice and service to both the applicants and to the citizens in equal measure. And over the years, I've endeavored to do this without fear or favor, including the day the then President Pro Tem of the Vermont Senate, the late Senator John Bloomer, came into my office seeking assistance in the Act 250 process to fight a proposed 130-foot-tall communications tower proposed to be located adjacent to his home on Boardman Hill in West Rutland. That tower was ultimately denied on aesthetic grounds. I did the same recently when Kim Gatchell and her husband Josh contacted me in the hope that they could obtain relief in the Act 250 process for impacts from the slate quarry adjacent to their home in West Paulet. In prior testimony, you are aware of the answer that I was obligated to deliver to the Gatchell family. So about the integrity of the Act 250 process. The legislature has mandated within the Act 250 statute that the public trust be preserved and protected by operation of 10 VSA Section 6031, captioned ethical standards. Among other provisions, the law states, the chair and each member shall conduct the affairs of his or her office in such a manner as to instill public trust and confidence, and shall take all reasonable steps to avoid any action or circumstance that might result in any one of the following. A, undermining his or her independence or impartiality of action. B, taking official action on the basis of unfair considerations. C, giving preferential treatment to any private interest on the basis of unfair considerations. Or F, adversely affecting the confidence of the public and the integrity of the district commission. With that law in mind, I note that the Vermont's draft bill proposes to replace the Natural Resources Board with the Vermont Environmental Review Board, which would hear appeals from the district commissions of the Agency of Natural Resources, in addition to the NRB's current duties. The Environmental Division of the Superior Court will continue to hear enforcement of local zoning appeals. I urge you to adopt the Vermont Environmental Review Board, as it strikes at the heart of the integrity of the public process that is Act 250. That process, as I feel obligated to share with you, is presently subject to undue political influence. How did this come to pass, and what are its manifestations? In 2005, the former citizen-based environmental board was replaced with a natural resources board and an environmental court was created to shift the appellate function on Act 250 appeals from that board to a newly constituted environmental court. When that happened, the ethical, if not legal, restrictions on direct communications between the governor's office and the Act 250 program were undermined. Let me put it another way. Act 250 is what is known as a quasi-judicial process, meaning that it is effectively a high-court executive, legislative, and judicial branches of our government. Once the application process is initiated and if necessary, a public hearing process is complete, a decision emerges at the district level based upon the statute, the rules, and the Administrative Procedures Act. That decision may or may not be appealed to the appellate body empowered by the legislature to hear such appeals. Currently, that is the E-Court. In court, this appellate body is expressly protected from ex parte communications by operation of the Administrative Procedures Act, meaning that with respect to the pending case, the court may have no direct discussions regarding the potential outcome of the case outside of the formal appellate hearing process. Lawyers call this the Chinese wall. However, as a perhaps unintended but unfortunate consequence of this shift in venue for appeals from the Environmental Board to the E-Court, the Chinese wall that previously existed between the governor's office and the Environmental Board has been effectively removed, resulting in routine communications between the governor's office and the chair of the Natural Resources Board. It's my understanding that they meet weekly. That change has had direct impacts upon the integrity of the activity process. How do I know this to be true? I have direct experience with respect to two examples. Example one. In 2015, my commission received an application from the Mountaintop Inn seeking approval of a 34-unit standalone satellite building located at its Act 250 permitted resort facility in Chittenden, Vermont. During the course of that review, the citizenry alleged numerous violations by the inn, all of which were subject to subsequent investigation and settlement and payment of fines arranged between the inn and the NRB. Between 2015 and 2016, it became apparent from interested neighbors that in addition to the violations previously mentioned, that the inn had created a formal home rental program directly tied by contract to 26 participating homeowners to effectively double the size of the resort's rental inventory. I informed the board that I expected receipt of a request and would be issuing a jurisdictional opinion on whether or not the routine contracted use of adjacent homes to expand the rental capacity of the resort constituted a material change to the Act 250 rules and therefore required the review and approval of the district commission and permit amendment proceeding. On the early morning of December 12, 2017, I received a call from the chair of the board when she informed me that Jay Pershing Johnson, the governor's counsel, had directed her to settle all matters associated with Mountaintop. And therefore, she and the NRD would not be supporting my jurisdictional opinion should it be issued an appeal to the E-Court. The chair went on to add, and I quote, "I could lose my job over this." I didn't question that statement at the time, and I don't question it now. I also believe that that sort of pressure fails to conform with the APA and with Act 250's ethical requirements. In any case, it's entirely unfair. Whomever sits at the head of the board. In the course of that call, I made notes which I preserved and will make available to the committee if requested to do so. On February 23rd, 2017, I issued jurisdiction opinion 1-391, wherein I concluded that the regular contracted use of up to 26 private residents, more than doubling the permitted capacity of approximately 32 rooms in Unions Lodge, constituted a material change under the rules with potential for significant new adverse impacts, such as traffic, water supplies, sewage disposal, and therefore required an Act 250 permit amendment to continue operating in that manner. Mountaintop Inn, you should know, is situated immediately adjacent to the largely undeveloped Chittenden Reservoir, considered a treasure by the local public who recreates in it. I should note as well, the primary septic disposal field for the resort, permitted to treat up to 9,000 gallons a day, went into complete failure in August of 2015, requiring what was effectively an emergency replacement. It was reported to me by the regional engineer that it was the fourth such failure of the system in the years that he overseen the wastewater permitting for the system. In my opinion, was subsequently appealed by Mountaintop to the E-Court. The NRB, who is by statute the party to all Act 250 appeals, did not participate. When the E-Court, in its decision on appeal, overturned the opinion, the matter was docketed for appeal to the Vermont Supreme Court, and the NRB has recently informed counsel for the citizen of Helen and counsel for Mountaintop that the NRB would not be participating in front of the Supreme Court on this case. For the NRB to decline to participate in a fundamental and wide-reaching jurisdiction issue begs for further explanation, and I feel obligated to bring it to the committee's attention. Example number 2. In November of 2016, the District 2 Commission was District 2 is down the southeast corner of the state. The District 2 Commission was dealing with a complex master planning case involving an out-of-state developer's plans to repurpose former Haystack ski area in Wilmington by converting it into an exclusive members-only luxury resort. On November 18, 2016, I received a request from then Executive Director Lou Corey to assist the coordinator in commission on the case. I agreed to do so immediately. After the weekend, I received an email from Mr. Corey informing me that, quote, all oral and written communication to the applicant parties in the commission should continue to come from the coordinator assigned to District 2, unquote. In other words, I was barred from any contact with the commission, the applicant, or the parties. While I had assisted other districts in many previous cases, I never received such a restriction on my ability to do the coordinator's job. It was evident on its face, but left unspoken, that my assignment in this case was to act as a ghostwriter, presumably to expedite the commission decision for this applicant. I immediately explained to Mr. Gorey that I found myself unable to work under these restrictions and the board would have to find someone else. In response, I was ordered on December 2nd to report to the board office to receive a quote, written reprimand for conduct deemed by Mr. Gorey and approved by the board chair as quote, unprofessional and inappropriate. That letter of reprimand is dated December 7th, 2016, and should the committee desire to read it, I will make it available to you. Given my understanding from the chair of the Natural Resources Board and others, the chair had direct meetings or discussions with the applicant, Jim Barnes, outside of the hearing process, I concluded that this special request was clearly intended to benefit Mr. Barnes by accelerating the issuance of a decision. On December 8th, I informed the NRB that having considered the limited resources of the NRB, the Department of Human Resources, and State Employees Union, I'd spare everyone the expense of a grievance or appeal and would accept the letter of reprimand. In summary, restoring an environmental review board's appellate function and rebuilding the Chinese wall between the governor's office and the NRB will serve to restore and to protect the integrity of the Act 250 process, and I urge you to do so. The slate quarry exemption. Because nearly 100% of Vermont's slate quarries are located in Rutland County, it was my job to develop and administer the slate quarry exemption the legislature implemented in 1995. I first developed a proposed registration application that included detailed documentation of the history and physical location of each hole on the ground. I was informed by then Executive Director Michael Zahner that the proposed registration is deemed unduly burdensome by the industry, and a pro forma registration was substituted. As mandated by law, I then issued 118 jurisdictional opinions, which in the aggregate probably total between 300 and 400 quarry holes. The explanation for that difference is that a single registration for a single tract would involve the exemption of multiple quarry holes, in some cases up to 7. This exemption is unique to slate. All other extractive industries are not subject to the ordinary rules of Act 250 jurisdiction. I urge you to pursue repeal of the special interest exemption. It is, in my view, bad for the environment, bad for impacted citizens, and therefore bad public policy. You've heard from a number of responsible slate quarry owners. I respect the hard and sometimes dangerous work involved in producing the product. Over the years, I've had very few complaints regarding any of those operators. The committee has heard that the public lacks access to adequate notice of the particulars on registered quarries. I agree with that, and I've included a sample of some particularly weak slate quarry registration drawings as an illustration of part of this problem. I think Laura will set me up with maybe an overhead or whatever, just give me examples of the mapping that a citizen might hope to find somewhere in the town records. All right, so there's one. So it's kind of like, good luck finding a quarry hole on that map. That actually is kind of one better up with bad ones. I didn't spend a lot of time going through the 118 and finding some really outrageous. I just grabbed about 10 and used the samples that struck me as being illustrative of the problem. So somewhere in there is a quarry. If you have the original, you can actually see a number 2 scratched kind of in the lower quadrant. You can see a number 3. So, good luck with that. And finally, somewhere on that is a quarry hole. But more importantly than worrying about improving the information available to the citizenry with respect to the location of holes and so forth, I think a broader public notice, better public notice, there is effectively no remedy, no recourse in the event that adjoining or neighboring properties are unduly impacted. It's not a meaningful way to approach the problem. The fundamental problem with the status quo is that it dooms the slate belt and the citizens who reside in to a nearly lawless environment. The problem rests not with the responsible operators who you've heard from, but the potential for the next 50 years and beyond that literally anyone else, including road operators or cowboys, will be free to reopen any of those 400 holes at any time in the future, with effectively no state regulation. That leaves the land and its inhabitants at undue risk. Ms. Gashel and her family testified that is simply not fair, and she's right. It's not the Vermont way. With respect to the potential for road operators, if we find agreement with the responsible operators, the potential for irresponsible operators is real. From times past, they know who I'm talking about. I experienced it personally when I asserted Act 250 jurisdiction over a quarry in West Pollock before the exemption was implemented, and at the conclusion of my site visit, I was told by the operator to, quote, watch my rearview mirror as I drove back to Rutland. The operators and I could tell you other stories, but we don't have the time today. So what is the remedy? How can we as a state correct this error? We simply repeal the exemption and require all quarries and their operators to go through the Act 250 process. I think it's entirely possible to fashion legislation and restore Act 250 jurisdiction to this industry without undue financial burden to those currently working active quarries. The process would go something like this. A committee made up of operators and interested citizens working with a facilitator to develop a set of stipulated permit conditions related to operations and what to do when or if a problem develops. All operating quarries would be required to file an application, and if proposing to abide by those conditions, the legislature could mandate that those applications be noticed publicly as minors, meaning there would be no public hearing unless one was requested by an impacted member of the public. If we had to have a hearing, we'd have one, and the perceived problems would be addressed. If no hearing was requested within 15 days, the permit would issue and be legally final, provided that the operator abided by the conditions. For those who come later in the future and propose to reopen an old quarry, they'd be subject to the same requirements that all other extraction industries are subject to, the regular Act 250 process. I would be happy to participate if asked to do so by the chair of the NRF in a project to work with the operators and citizens to fashion this sort of remedial process. It's not a perfect solution. We still have the very difficult issue of site reclamation to deal with, but it would go a long way to restore a sense of fair play to the citizens of Western Rutland County. I'd like to close my testimony on a positive note. The chair of the Natural Resources Board and her leadership team in Montpelier have made great advances in making the application process more efficient electronically and making each application more readily accessible to the public. These successes deserve recognition and will go a long way toward advancing the governor's focus on transparency. I think that the creation of a professional or semi-professional environmental review board to hear appeals and the repeal of the slate exemption will further the goals of open government and a fair playing field for the citizenry. Thank you so much for giving me the opportunity to share this with you today, and I wish you all well in the difficult task ahead.
Thank you very much.
You're welcome.
Questions? Representative Smith.
Yeah, I'm looking at your map there, and you said that there was a quarry hole in there someplace. I'm wondering, are these properties mapped on a town map so they have some idea where the boundaries are?
They are, but not every registry views town maps to mark their quarry holes, and not every registrant did a very good job of actually locating the physical location of the hole. You might put a dot somewhere, but it ended up being nothing's really to scale, and if you get precise about it, there could be disputes, there have been questions, so very unreliable.
So people in that area don't know where their properties are? I mean, is that what I'm just hearing?
Do you mean the owners don't know where they're?
Well, yeah, I'm trying to understand, I'm looking at that map and I can agree with you that, it isn't really well defined. But I also know that all towns have property maps and parcel maps, and they're laid out so you know where the parcels are. Huh? Yeah.
Yeah. Well, I agree completely. When I was tasked with generating the registration program, it was, as I mentioned, pretty, I'm not going to say it's onerous, but it was much more detailed with respect to having scale drawings of your property lines, the scale to the location of the slate quarry holes or pre-existing buildings that you were representing existed. It would have been better. It would have been way better in terms of at least identifying. But what I tried to emphasize in my testimony to you was that simply having better ways to find out that you're out of luck as a citizen. We now have this great map of this great thing, and that quarry hole is 350 feet away from my home, confirming that you're out of luck, because that's the law. If the properly registered, you're exempt. And somebody can come in later this afternoon and start blasting legally. My point that I was going to emphasize is that dummy registration programs don't really get at the fundamental problem that actually something this particular industry. I don't know if that your question.
Well, I'm trying to understand the issue, because property rights issue for every piece of property, not just for slate quarries. And I'm trying to understand it. It's kind of a new concept to me to have these, what do they call them, reserved rights or reserved something to allow them to come in and either create a new quarry or to reinvigorate a quarry that has been set idle for a while. So I'm just trying to understand how we got in the situation we're in. I've seen testimony on both sides of the issue.
Sure.
And I'm just trying to work my way through it.
The industry at the time represented that their industry was unique, it was special, that the market shifted over time, and that people went into quarries and out of quarries depending on market demand and so on and so forth. And that to spare the industry from, essentially from the Act 250 process, we would recognize the unique special characteristic of this. Which I would say, it's an imperfect analogy, isn't it? Analogous to saying that you can build a 130,000 square foot building, and once it's an abandoned relic, it'll stay in reserve forever, because somebody might want to reopen it someday. And we don't have that kind of option for other pre-existing development in the state. So I thought, to get to your point, what was the rationale that we ever did this to begin with? I think it was a faulty basis. Not wholly divorced from the fact. I mean, the demand for blue slate or red slate changes and so forth, but like any other industry, you deal with the market, you deal with whatever requirements are in place at the time, rather than exempting the whole.
Representative McCullough.
William, thank you very much for coming and giving us your professional and concise testimony today on several very important issues that we're wrestling with. This question is on the slate, and in my mind, I guess, but I would just say, as soon as this bill becomes law, boom, you gotta go get an Act 250 permit if you're a slater. But I recognize in real life, we don't wanna do that to the families that run those businesses. They need some kind of a soft landing, if you will, some kind of ability to work within a system that they were given a long time ago and now is going to be changing. And so the other part of me says, okay, then I'm going in the area where I think you suggested, although I hadn't thought of creating a working group, which I think is a great suggestion. But the issue for me is really defining what are the working holes that we're dealing with right now? And what are the other, if we're gonna assume there's a total of 400 holes, what are the other 375 holes? And which we did get testimony from the industry, are the size of this room. And which we can see by your photos, really, where are they? We don't know. And so it would pretty clearly take some people on the ground with their GPS locators to go around and locate the, what I might call legitimate working holes. And then that might be the baseline. Everything after that automatically has to get an Act 250 permit that deals with all the things that the new Act 250 law will embody. But perhaps the legitimate holes that the committee identified and would get some sort of other largesse, I will say. And could you, this is a pop quiz, and this may be, you may not be prepared to kind of like outline 3, 4, or 5 different of the criteria or how they would be manipulated in order to facilitate this for the ongoing pools. But if you'd give that some consideration and get back to me, or maybe you can just go, yeah.
I can.
Awesome.
You ready?
Yep.
Yeah. Yeah, we would, I think it'd be relatively easy to identify the currently operating holes. I think we would probably gain the cooperation of the majority of the responsible operators in doing that. So, once we would get a committee together, we would seek input from the citizenry and from the operators and set up, as I mentioned, a set of stipulated conditions agreeable to the industry. You know, what hours are reasonable? How can we do our business during what hours? What blasting circumstances? What time of the day will we agree to blast during? If a citizen nearby requests notification of blasting, will we be happy to provide it? And I assure you they will be happy to provide it. One of the things that you find in the world of blasting and earth extraction is it isn't so much the big kaboom that bothers people. It's the being surprised by the big kaboom. It's surprising how much prior notification. You know, we're gonna set up a blast today about 1:30. It's surprising how much if a citizen knows that's gonna happen, how much it reduces their sense of the impact. So simple notification plans. There'd be special circumstances for some of the operators where there happens to be a home, you know, immediately adjacent and so forth. In that particular case, we'd look at whether or not it's appropriate to set up some pre-blast surveys of the homeowner's foundation and their wells, so that there would be a baseline. And then if operations in the quarry, you know, negatively impacted that person's well or foundation, we have it built into the condition, what's the remedy? And the remedy would be agreed in advance by the operator and by the homeowners and so forth. It would all be part of the permit issue to operate in the quarry. So I think we could get to a point where the currently operating quarries would be agreeable to what would amount to a basic Act 250 permit that we would issue as a minor. And if the citizens around that quarry were in agreement, didn't raise their hand in 15 days, the permit would issue, they'd have a legally final Act 250 permit for as long as that permit life was set for, whether it be 20 years, 30 years, whatever. And then, as you mentioned, the balance, essentially what the legislature would be doing would be taking all the other long abandoned quarries, with all of our worries about trying to find them. Literally, some of these things were represented as being half the size of a table, one of these tables. Yeah. The legislature would be effectively deeming those abandoned by non-use, and to reopen that little table one or a brand new little one over here, or any one, you go through the regular Act 250 process.
Good, thank you very much.
Yeah, I would like to.
Representative LaFave.
Thank you very much for your testimony. I was intrigued to hear about the Chinese wall. One of the things we've been kicking around quite a bit is in creating changes in Act 250. How do we create a sense of impartiality and fairness? And the example you cited about Mount Tom and the relationship between the NRB and the governor suggests to me anyway, political skullduggery or some undue influence going back and forth that basically caused the NRB to step aside and even more or less tried to reprimand you for the decision for your jurisdictional opinion you gave. And yet you seem to think that a citizens review panel would be preferable over a court. And I'm just puzzled as to how you wind up with that conclusion given what happened in that case.
My experience with the environmental board, because I've been at this for 26 years. The environmental board existed from 1970 up to 2005. When you have the same group of citizens acting as the appellate body, as the environmental board did, then both the governor and the chair of the environmental board understood that there was a Chinese wall, that it was no more proper for the governor of the state to call the chair of the E-board and say, can you help the applicant X out a little bit? No more appropriate to do that than to have the governor call a judge. Judge, I know this case you're working on, can you believe it now? And everybody understood the rules. And I think, to my knowledge, they were abided by pretty scrupulously. So when you eliminated that, and you sent all the appeals to the E-board, the channel between the governor's office and the chair of the board was substantially, those sorts of both legal and ethical, provisions to prevent the skullduggery or whatever, they were substantially undermined or diminished. To a serious extent. In my world, if we lose the integrity, if we lose the public trust, if we lose the fundamental trust that the public has when they go into an Act 250 hearing, that they're going to get a fair shot. If we lose that, then anything else we do with Act 250, in my view, is
Just to make sure I understand, the public's trust is, in this case, is in the impartiality of the court, is it not?
exactly.
And by now taking that decision-making away from them as far as the appeals go, and giving it to a citizens board, I guess that's where I'm having trouble. I mean, why would I would not want it to be retained by the environmental court? Simply because I think there's going to be less political influence with the court than I am with the citizens panel.
Right. Once you set up the citizen panel, you have the Chinese wall between the governor's office and the panel. The district commission issues its decision. The citizens generally, I think it's fair to say, feel more comfortable pro se at representing themselves in front of a semi-professional citizen panel than they would in the court of law. So they'd be more comfortable going in. The answer that the chair of the E-board would give when they got a call from the governor's office, and I know this happened on more than one occasion with the environmental board. The chair of the environmental board would get a phone call on a particularly troublesome case. I won't mention CNS grocers, but I just mentioned it. And the chair of the E-board was in a position to say, Governor, I simply can't talk to you about this case. It's pending, and we're gonna be hearing the appeal. You understand when you are not the appellate body, as the current chair of the NRB is not, that kind of prohibition, that kind of bar for that kind of ex parte communication is really not there.
Thank you very much. We need to move on.
Thank you, sir.
You slide them. All right, you have Judge Grierson. Next. Okay, I'll add for a little oxygen.
Live in an old house, you don't know these things.
How many legislators are
Now we know
supposed
the
to
role of the vice chair. Thank you.
Welcome.
Thank you, good afternoon. I want to thank the committee and the chair for inviting me here. For the record, Brian Grierson, Chief Superior Judge, speaking on behalf of the judiciary in relation to, I don't think it has a bill number yet, but Act 250 reform. And I do want to take the opportunity to thank the committee for having us up here. I think this is the first time I've appeared before your committee, so I'll give you a very brief background. I've been 15 years on the bench. The last 4 years, or 4+ years, I have been in the role of Chief Superior Judge, which means when I'm not appearing in the legislature, I'm doing it private. I'm assigning judges around the state within our divisions. When the legislature is not in session, what I call the off-season, I still sit in as many dockets and courts as I can around the state. Before taking the bench, I was a practicing attorney for approximately 30 years, primarily litigation and civil, family, criminal matters. And all of that brief summary is notable only for what I had not mentioned, and that is I've never appeared either as an attorney in the environmental court, nor have I ever sat in the environmental court. It's the only docket I have not sat in. So in that respect, perhaps like many of the members of this committee, I have more questions than maybe I have answers, but I will do my best to answer any questions about this proposed bill, particularly the area that relates to the appeals process. I recognize that this is certainly a policy decision on the part of this committee, on the part of the legislature, to change the process that has been in effect for approximately 15 years. The judiciary does not take a position pro or con on policy matters. What I hope to be able to do this afternoon is to tell you what I think the impact would be on the judiciary and on the environmental division, and some comments about the process that we are presently operating under. In terms of impact, I believe that our office, I believe, the Court Administrator's Office has previously supplied this committee with 2018 fiscal year data on environmental court. If not, I can certainly provide that information. But as I understand the structure of the bill at the present time, appeals would go to an administrative tribunal, back to 50 appeals, as well as municipal appeals. That represents, at least as of 2018 fiscal year, about 50% of the case filings in the environmental division. Of course, the environmental division is only one of the divisions of the judiciary, in addition to the criminal, family, civil, and the probate division. That 50%, those appeals representing approximately 50% of the case filings, represent a more substantial impact on the work of the court, meaning that of that 50% filing of those appeals accounts for approximately 70% of the workload of the judges, and even greater percentage of workload for the staff relating to those appeals because of the nature of the work and the complexity of the issues that come before the court in reaching those decisions. So if that number of cases were removed from the environmental division docket, it would reduce it obviously by approximately half. It would have a significant impact then on the operation of the environmental division. But having said that, understand that the environmental division, being only one division, is one of our statewide divisions, meaning that many of the people involved in the operation and management of that division, environmental division, also have responsibilities and duties in other divisions. For instance, the clerk is also a clerk of the Judicial Bureau. At the same time, she operates as the clerk of the environmental division. The court operations manager has duties in other divisions. Most of the people, most of the staff, if you will, in the environmental division have been with the judiciary longer than I have been with the judiciary. They are essentially embedded in the administration of the judiciary. Therefore, even if the workload, if the case file didn't workload, the staff would still be there. They would be devoting perhaps less time to environmental matters, but because they're already working with other dockets now, those duties would be expanded. Most of the folks working in the environmental division now have come from other divisions within the judiciary, and are now obviously working in those areas simultaneous with other divisions. The judges are in a different situation than the employees. Obviously, they are appointed by the governor and go through the formal appointment procedure process that all Superior Court judges do. But because they are Superior Court judges and appointed as such, although they are assigned initially to the environmental division, they, under statute, as part of the duties I mentioned earlier, scheduling, assigning judges throughout the state, can assign them under statute to up to 2 years out of the environmental division. And even at the present time, they from time to time will fill in other divisions as the need arises, either due to medical emergencies or other judges not being available for vacation or other issues. So even at the present time, periodically, they will be assigned to another division, oftentimes for a one-day session. But the bottom line is that as much as the impact that this would have on the environmental division itself, it would have minimal impact on the judiciary's operations. In other words, the people who are working in the environmental division could be assigned to other areas. I think that's important because at least I've tried to follow the some of the testimony that's been presented to the committee, and I know there was at least one witness who suggested that if you reduce the workload in the judiciary, that they would just reallocate those resources that the judiciary is losing to help establish or administer the administrative body. The reality is that there would not be any resources that would be coming out of the judiciary. And so in that sense, it would not impact our operations in that regard. So I think in terms of impact, just to conclude that part of my testimony, it's clear it would have a significant impact on the environmental but it would have no impact on the judiciary. So, even under if the bill were to pass in its excuse me, present form, under the statutory framework that exists, because of the skills that these judges have acquired over the time they've been on the bench, and one of them has been there almost since the inception of this new legislation, Judge Durkin. Those are skills that have been acquired over time and not much in the so that under the existing statutory framework, if their workload was reduced in half so that it became essentially a one judge court division, my plan would be to alternate those judges periodically so that we maintain the skills that they've acquired over the time they've been on the bench. I think in no small part, this committee is in a very unique, it's a very unique opportunity. You are considering a change in policy, a change in the procedure involving appeals that by their very nature are complex. That in doing that, I think it's fair for this committee to look at the legislation that created the existing system back 15 years and look at what the legislative intent was at that time. Look at the purposes of the legislation and what was hoped for by that change to the current system, and ask yourselves how has the process measured up? How has the court system measured up to what the goals and purposes of that legislation were? And if changes needed to be made, then it's appropriate to consider changes in the existing system. But I think in looking at those changes, you would have to, and you have the opportunity to look further and say, are the changes or to the extent that the court system has not accomplished what the legislature intended, does that mean you go back to a system that was rejected by the same legislature 15 years ago? You really have to ask yourselves, why do we want to go back to a process that was rejected? And I think that's an issue that the committee should be discussing. And I think in deciding how the court process that was set out, how is that measured up, I would hope that you would be guided not by anecdotal stories, but by data. And look at the data and see if the data supports what the legislature intended in making that change in 2004, 2005. I think the hallmark of any process, any court process, any tribunal, is consistency and predictability, and efficiency in the operation of that court. And I apologize if you do not have those statistics. I will get them to you, but for the fiscal year 2019, there are a number of ways you can look at those statistics and measure how has the court responded to this. And one measure that we use that you'll see in those statistics is something called the clearance rate, meaning we look at the number of cases coming into the system in any one year, and we look at what we've disposed of. If we can achieve 100% or close to that. What that means for individuals coming before the court is that we're not building up a backlog. We're at least disposing of the number of cases that are coming in, and if we exceed, you'll see from the numbers that in a number of years we've exceeded that rate of 100%. That means we're not only not creating a backlog, but we're eating into any backlog that exists. When you again look at the figures, you'll see that I believe the number is, I want to say it's 85%. I guess I can show you what this looks like. Maybe it'll tell me right away whether you've seen it. They've been.
So I know the commission saw it, that's why I was
Okay,
like, when you
that's-
said that, I was like, I know that I've seen it and Paul has seen it.
Okay.
I'm not sure this committee has.
I will make
them or
sure
not.
that we get those to you, to have in my testimony. So, and those are the charts I'm looking at, it's fiscal year 2018. And that's where the numbers came from. 51% of de novo proceedings representing appeals. And just hold on the number to you. I can show you. This is what I was talking about, the so-called clearance rate. You can see this graph that goes over a number of years. It goes up a little. So that's 2014 to 18. So at sometimes it was never out of 90% out of it. Sometimes went up to 110, 112%. And then we're processing cases, we think, in a way that lends itself to the issues that come before the court and staying ahead. I think the number, if I can find it, 85% of cases are disposed of in less than a year. I think that's the number I had. Fiscal 18, 84% of the environmental cases disposed of within 12 months of filing. The method of disposition, over 50% of them were disposed of by agreement. Final decisions issued by the court in approximately a third of the cases, 29%, and 18 were dismissed or withdrawn. This is a system and expertise that has been built up over the time that the judges, current judges have been sitting. And I think that's demonstrated not only in the manner in which the cases are disposed of in a timely fashion, but one of the items I gave you to go with this machine.
I fell asleep too, sorry.
Better than machine. I can just tell you the statistics.
Sure.
It's all right. It's
We have it also.
the other measure I would ask you to look at, and I think this is important as you consider changes to the current system. In over 200 decisions involving both of the current judges that went to the Supreme Court, 15 of them were reversed or remanded. And for those of you that aren't familiar with the legal terminology of remand, it essentially means that the Supreme Court has sent the case back down to the judges to say, we need clarification or further findings to support the decision that we made. So every reversal and remand isn't a rejection of the court's decision. It may be that they need to clarify. Why I think that record is important is, as stated earlier, whether you're talking about the criminal division, the civil division, family division, probate, or environmental, what is important is consistency in decision-making and predictability. So that in my view, that the process that is taking place in Bennington, and the issues that come before the court down there, keep in mind, although these are only the two judges and it's a statewide court, when they hear cases, they go to the county where the case originates for hearing. But I would think that the committee and the legislature would be looking for consistency statewide. And I think that's what these judges have been able to provide. data is important. I think, as I said earlier, I'm looking at where you are in this process, before you can look at, I guess I would suggest that the committee should look at what about this process that's been in effect for 15 years hasn't worked, if you don't think it's worked, and what is the data to support that, as opposed to the anecdotal stories that all of us hear in any committee. And so they have a place, for sure. But I would hope in looking at something that's complex as 250. And I've read some of the comments that folks say that the process is too complicated, that it makes it more difficult. And I would suggest that the court process, certainly when the legislature passed this legislation, they were saying to the court, you take responsibility for all of these. The court and every division operates by rules. So there's nothing unexpected about the court process or the fact that the court has issued rules of procedure, rules of process, as they do in every single division. And we set guidelines when these cases come in, to set milestones, to measure the court's progress, measure the judge's progress of a given case, to see if it fits within the guidelines that we have established for the type of case that it is. It can vary. And I think all of that is important to this process. And I know that there have been discussions in committee about access to justice, and perhaps a feeling by some individuals that you have heard from. They're saying that self-represented litigants struggle with this process. And in some respects, I have no doubt that that's accurate. But you have to ask yourselves, are they struggling with the process of Act 250 and all of the criteria versus the process, the court process? Because Act 250 is a complicated process, regardless of whether you are self-represented or whether you are hired by as an attorney to represent someone. I think, and the document that was filed with the committee also speaks to the efforts this division in and of itself has made, recognizing that a number of individuals in this process are self-represented. I asked for some numbers just before I came here. The numbers are a little different than the ones on the chart, because the numbers I was given were for calendar year 2018. There were about 140 filings for calendar year 2018, and in at least 40 of those cases, there were self-represented litigants. That's a number, quite frankly, in the difficulty that any self-represented litigant has. It's not different. It's not unique to the environmental division. In some of our other divisions, the percentage of people representing themselves is well in excess of 50%. The family division, for instance, is well in excess of 50% of self-represented litigants. In the criminal cases, they're maybe not as high, but they're self-represented litigants. Certainly in the civil arena, some of our largest dockets in the civil arena are mortgage foreclosures and rent escrow proceedings. Obviously issues that hit the home of everyone, and obviously involving very emotional, personal issues. And most of those dockets are represented by people representing themselves and don't have the benefit of counsel. So the issues that you're hearing from self-represented litigants are in no way unique to the environmental division. We are seeing, certainly in the time I've been on the bench, the inability for people to retain counsel to afford counsel. So we are impacted. But this division has taken steps in creating a self-represented legal clinic with the Vermont Bar Association to to provide folks in facing these obstacles with counseling and advice of attorneys on a voluntary basis, to set up appointments at any point in the process. And I think that clinic, if you will, is unique to the division, and it's something that was created in recognition of a number of self-representative. They have a mediation program going, again, to assist the process. So I think all of these steps, and that's in the document that I filed with the committee, and I won't go into more detail. But I think you have to take a hard look at what the legislature 15 years ago wanted, expected, and have we lived up to that, and decide whether the answer is to disregard that completely, for lack of a better term, throw a milk baby in the bathwater, or go back to a system that was rejected by the same legislature. As I indicated in my early comments, I never appeared in environmental court, I never sat in environmental court, and I really did not know the history of how we've arrived at this point. So I started looking around to try to get some of that information myself, and I came across an article, and I'll conclude with these comments, in the Vermont Bar Journal, I think it's about 10 years ago, 9 years ago, by Paul Gillies, who I don't know if he's appeared before this committee. I'm sure he's appeared before the commission. But my experience with Paul Gillies is he has a tremendous, most people have a tremendous amount of respect for his opinion. So he writes in this article, and this was 2010, he was talking about essentially perhaps a 20-year summary of the history of the environmental board and the appeals process. And I recommend the entire article to you, but at one point he sums up by saying this: like zoning, Act 250 was supposed to be a law administered by laypersons who would use their judgment and common sense in applying the facts of an application to a set of zoning bylaws or subdivision regulations. But the environmental board's perceived record of overreaching in its attempts to expand the jurisdiction of Act 250, along with its record of reversals in the Supreme Court, led to its dissolution. The environmental board would become what the environmental board could not: a place where legally trained judges with a growing expertise in environmental law would rule on questions objectively, without any bias or predisposition. The law, not philosophy, would decide contested cases. I offer that comment. Guidance and yes, thank you. I'll try to answer any questions.
Thank you. I guess one of the things that struck me in previous testimony that I'd like to hear your thoughts on is that idea that the courts are set up to kind of help two people having a conflict, and Act 250 is kind of more trying to assess the holistic impacts on a community and probably on public trust resources. So I guess I'd just like to hear your thoughts on that.
Well, I think there has to be a balance. I mean, ultimately, there has to be a decision on whether a particular project permit is granted. And ultimately, I think the Act 250 criteria is what provides that holistic approach. Ultimately, there has to be someone making a decision whether or not a particular permit meets that criteria. So I think even a judge in making an ultimate decision on a particular project takes those factors embedded within the act.
Any other questions, Kenny?
Good afternoon. Good to see you. And thank you for your testimony. I appreciate your thinking about criteria, the type of criteria, and having statistics to help illustrate the usefulness in thinking about criteria and evaluating this type of approach for handling appeals. And you specifically focused on clearing rate as that criteria to look at consistency and predictability. And I think that you're accurate. I think the public interest is to ensure that, like any statute or any law that we are writing, is promoting consistency and predictability to all people when it comes to the health and welfare of the public and the decisions we make. Yet there are other criteria, I imagine, that we would want to also acknowledge as being important in the public interest. And I think you referred to anecdotes, but those anecdotes help to reflect the concern that we can raise if we don't consider some of those other criteria. What comes to mind is the impartiality or without political influence, I think is a really important criteria that we should be looking at to ensure that we're providing fairness in our decision making. Can you respond a little bit more about some important criteria when it comes to making decisions to ensure in the public interest that we're making decisions that are without political influence, are impartial, provide fairness for a greater, more accountable, more transparent government?
So let me say first of all that it's suggesting, for instance, the appearance rate, that's only one measure. Obviously there are other measures. But I think if I understood your question correctly, if what you're looking for from a process is impartiality and free from political influence, I can't think of a better place to put that decision making than in the court. I heard the gentleman before me talking about the previous system and the idea of building a Chinese wall between divisions. About the time you're creating a Chinese wall, you've got to ask yourself, why am I building that Chinese wall? Why do I need a Chinese wall? If I have to build a Chinese wall, then there's got to be a reason. And I'm not familiar with the old system, so I've taken that as word that there was some perceived need to have that. But because of the appointment process, the retention process, the judges go through that process every 6 years. We just finished one a few weeks ago. So I don't know that the court system, I don't know that there's anything better than the court system to provide that impartiality and freedom from political influence. The judges are retained for 6-year terms and vote for retention every 6 years. I don't know if that answers your question, but
I think that is helpful. I think in the anecdotes we heard when there isn't representation on trying to problem solve as the chair had sort of described, the important role of Act 250 in the appeals process is about problem solving a conflict. And when one party isn't necessarily a party to the appeals process, it implies that although the court may be set without having the representation there, it can fall short of providing that impartiality or that fairness, the opportunity for fairness.
I guess my last comment would be if someone is not a party to the legal process, then clearly they're not going to be heard. But the question I would ask is why, if they have that important of an interest, why are they not a party to that particular process? So I wouldn't have to be on an individual case-by-case basis to answer the question why whoever came before you, if they did not have party status in the court setting, that's the tip of the iceberg. We've got to ask why didn't they, and did they have an interest that under the rules that apply to the process and procedure, were they eligible or not to have party status? And again, without knowing the details of that particular case, case on that individual is hard for me to say, but I certainly understand the importance of being heard and gaining party status. I think there's a significant portion of Act 250 that talks about how you gain that party status. Before the court gets to rule on that, there are criteria to follow to achieve that party status. The court is interpreting, as it does in every statute that you pass, has to interpret that statute as it relates to that particular case and that individual.
Thank you very much.
Thank you. Thank you for your time.
We're gonna, take a 5-minute break. 5. Welcome.
He'll cook it.
Greg?
Thank you.
Tony?
So, Greg Boble, General Counsel of the Natural Resources Board. I think there's high expectations either that they're going to solve global climate change and or present a really exciting PowerPoint here. I don't think either of those are.
Can you do either one of them?
I'll do my best, but the short of it is I've been asked to lead a discussion or walk through some of the legal standards that we implement here at Act 250. The two legal standards I think that are in question and that I was asked to provide some guidance on are the undue adverse standard and the avoid, minimize, mitigate standard, which I think the Commission has, or the community has been exploring with respect to 3 criteria: climate change, forest blocks, and connective habitat. So I had originally planned 30 minutes, and then I think my time went to 45 minutes, and I think now we're back to below 30 minutes. And I had planned to walk through the following, following fundamental issues. A general description of what undue and adverse mean, what current criteria incorporate undue or adverse, or both. And I thought that we would do that just so we could see how, in practice, undue and adverse is implemented. And that's implemented through the Pucci analysis, which I know the committee's heard a lot about over the course of the last few months, but maybe hasn't actually seen what it does and what it is. Just a quick review of other legal standards that show up in Act 250 for frame of reference. We're going to go over the authority to condition, which is sort of at the heart of Act 250. Where does our authority come from? What does it look like? How do we incorporate conditions so that a project will meet the criteria? Then we're going to look at the avoid, minimize, mitigate model by way of a current example, and then we'll take a quick look at the proposals that are on the table. And in advance, I'm going to apologize again. A lot of this is pretty word-heavy, and so we're going to do a little bit of reading. But it's important to kind of understand how the courts have interpreted various issues and how they're applied. And one of the best ways to do that is to look at old decisions and old but relevant decisions. So how are undue and adverse defined? The term undue generally means that which is more than necessary, exceeding what is appropriate or normal. The word adverse means unfavorable, opposed, hostile. Scenic and natural beauty pertain to the pleasing qualities that emanate from nature and the Vermont landscape. In short, through criterion 8, and again that's the aesthetics criteria, the legislature has directed that no project within our jurisdiction be approved if it has an unnecessary or inappropriate negative impact on the enjoyment of surrounding natural and scenic qualities. Criterion 8 is therefore sufficiently specific to constitute proper delegation of power prescribed by the Constitution. So this quote does 2 things, and it's from an earlier environmental court decision. 1, it defines adverse and undue, and 2, it indicates that the term and the standard has withstood a constitutional challenge. Because there was some question as to 1, whether it provides a proper due process, and a corollary to that was whether or not it was too vague to withstand a constitutional challenge. And this court at least found that the standard is not too vague and withstood and therefore withstood a constitutional challenge. So existing criteria that incorporate undue or adverse or both. And so this is interesting to me. We talk a lot about undue and adverse with respect to Act 250, but in fact, there's only 3 of the total 32 criteria, sub-criteria, that in one way or another incorporate either undue and or adverse. The first one is criteria 1, will not result in undue water or air pollution. The second one, which is the only criteria currently to incorporate the term undue adverse, and that's the aesthetics criteria 8. And then 9A also incorporates the term undue, and that criteria is set to curtail impact on, on municipal services. So again, currently, under the current Act 250, there's only one criteria that incorporates the term undue and adverse. So how has that term been analyzed by the courts and by the Environmental Board? So again, as you all know, the Act 250 has been around since 1970, and this particular criteria, aesthetics, was one of the original criteria. It went for a number of years without having a specific analysis tied to it, and I think that the Environmental Board and the district commissions had a hard time administering the analysis with respect to the term undue and adverse. And it wasn't until the early 80s that the Environmental Board announced its decision in the Quechee Lakes case that articulated a test to determine whether or not a project is undue or adverse with respect to the aesthetics criteria. And the Environmental Board implemented a 2-pronged test. The first prong asks whether or not a given project, subdivision or development, is adverse. Will a project have an adverse impact on the aesthetics and the scenic and natural beauty of the area because it would not be in harmony with the surroundings? And the Environmental Board looked to both the context and the scope of a project in order to make this determination. If the district commission finds or found that a project is not adverse, then the query is at an end, and the project would pass that criteria. Otherwise, if the commission found an adverse impact, the second part of the test is whether or not that impact is undue. And there's a 3-prong analysis in order to make this determination. If any one of these prongs is satisfied, so in other words, if we answer any of the 3 questions in the affirmative, then the project would be undue. And so it's worth just reading through these factors real quick. 1, does the project violate a clear written community standard intended to preserve the aesthetics or scenic natural beauty of the area? Number 2, does the project offend the sensibilities of the average person? And number 3, have the applicants failed to take generally available mitigating steps that a reasonable person would take to improve the harmony of the proposed project with the surroundings? In a nutshell, that's the Quechee test. Commissions implement this test regularly, and from time to time, the courts have an occasion to implement the test. It's pretty well set in stone. There haven't been any challenges to the test. Though it took some time to develop, it seems to work rather well. I included this slide just to give the committee an understanding that there are in fact a number of other legal standards that we implement on a daily basis.
Are we moving off of the undue adverse?
We don't have to. I was planning to, but we could certainly come back.
My only question,
Sure.
if I may, is that I know the Rivers program uses no adverse impact related to floodplain, in particular to ensure that we are not increasing the vulnerabilities of development. Should we be building on vulnerable areas for flooding? And I don't see that described here, and that would be under criteria 1.
That's right.
So I only flagged that.
Okay. Yeah, so criteria 1, let's just go back to criteria 1 real quick. Uses, look, the actual standard in the criteria is undue. The words, I think, sometimes are used interchangeably, but they're, you know, I can't speak with any great detail with respect to your.
I wonder if it would be helpful for us as we go through the updating process, whether we need to look at that
Sure.
particular criteria.
Sure,
Okay, we
I
can
think
move
that's a
on.
good idea,
That's
and
fine.
then a number of the criteria, not just the 4 that I have listed here, use the unreasonable standard, which does not have a whole lot of legal guidance, I think largely because there's that standard reasonableness has been analyzed in different contexts over the years. But criteria 3 with respect to the burden on existing water supply, criteria 5, which is traffic with respect to congestion, criteria 6 with respect to the burden on municipalities to provide educational services, and on 7, those all use a different standard, which is the unreasonable standard.
So say again what you just said about unreasonable, it's not.
I did a little research to find out how the courts have analyzed the term unreasonable, and I didn't find, in the limited research I did, I didn't find a really good, concise explanation of what unreasonable means. I did find a number of examples that found a project to be unreasonable or reasonable, but no really good, succinct definition of how that term should be evaluated. So I included this slide just to give the committee an understanding as to where our authority comes from. When I say ours, I mean the Natural Resources Board and the district commissioners, where our authority comes from to condition projects once there's a determination made that there might be concerns with respect to the way that the project was proposed to be implemented. And so we have a relatively broad authority to condition projects by way of a permit and by way of permit conditions. A permit may contain such requirements and conditions as are allowable proper exercise of the police power and which are appropriate within respect to the criteria. So the police power, the statute as it exists currently essentially references the police power, which is a constitutional power granted to the states or retained by the states. And there's some case law that dives a little bit more into the scope of the police power with respect to what might go beyond the police power and therefore be unconstitutional, and what has been found to be appropriate use of inappropriate use of the police power. So permit conditions are reasonable and within the proper exercise of the police power when they are intended to alleviate an adverse impact that would otherwise be caused by a project. So it's rather broad. The exercise of the police power is justified if there is a reasonable relationship between the agency action and the legislative ends sought, and if the agency action is premised on an appropriate overriding public interest. So those are sort of like affirmative uses of the police power. The limitation is in the final piece of this slide, which the courts have indicated that regulation that goes so far that it has the same effect as a taking by eminent domain or is an invalid exercise of the police power violates the due process clause, which ultimately would be a condition that would violate the Constitution and would be unconstitutional. And I offer you that slide only to give the committee some context as where our authority comes to make sure that a project conforms with the criteria.
Can you give us an example of such a regulation?
Of condition?
Yeah.
Sure. So, I mean, there's every Act 250 permit has conditions. Some conditions that come up more regularly are conditions on buffers, for instance. You know, thou shalt not mow your buffer within 100 feet of the street. That sort of condition is a very common condition. Condition that requires a large development to pay for traffic controls, be it a live police person during certain operating hours, or be it actual physical mitigation on the transportation infrastructure. There's all sorts of conditions that the commission can require that a permittee comply with.
Representative McCullough.
So, could you, I think I understand, but what are you talking about police power? What police power is it? What is this, what do you intend to be telling us?
Not that the commissions have the authority to dress up as
No.
policemen or women, but the authority, the police power is a power that's authorized to the states to make certain that they're able to implement their laws and to make certain that they have some level of control over various functions of the government and of the public. So it's a pretty broad power that says, state, you may authorize, you may have some control over the way that, in the context of Act 250, you can institute a program so that you can make certain and require that projects comply with the criteria. It's just a power that allows a state to implement its rules.
So this is derived from federal,
From the Constitution.
from the Constitution that gives, such as we're a delegated state for water quality.
That's exactly right.
Okay, good, thank
Yes.
you.
So, avoid, minimize, mitigate. So there's an existing model for this process in Act 250, and I think that there was an original proposal, at least as a draft 6.1, that implemented avoid, minimize, mitigate for climate change, for forest blocks, and for connected habitat. I think in the most recent draft 7.1, the mitigation may have been removed for the second two. So primary agricultural soils more or less has the same setup in its current. Well, I think it might be worth just reading through this and maybe having a brief discussion on how it works in practice. So this is criteria 9B, primary agricultural soils. A permit will be granted for the development or subdivision of primary agricultural soils only when it is demonstrated by the applicant that either the subdivision or development will not result in any reduction in the agricultural potential of the primary agricultural soils, or, so that's the avoid part, right? Will not result in any reduction, that's the avoid part. And then there's a list of 4 things that have to be complied with if there's going to be some reduction in primary agricultural soils. And I think the most pertinent one is the third one, which is the minimize test. The subdivision or development has been planned to minimize the reduction of agricultural potential of the primary agricultural soils with innovative land use design resulting in compact development patterns so that the remaining primary agricultural soils on the project tract are capable of supporting or contributing to an economic or commercial agricultural operation. So that's the minimize part. Avoid, minimize, and I've highlighted the word and there because in the proposed legislation that included the mitigation piece, there was an or. Not for primary agricultural soils, but for climate, forests, and connective habitat, which is, I think, pretty important here. Ultimately, the 4th test or sub-test in prime ag soils is suitable mitigation. So suitable mitigation will be provided for any reduction in the agricultural potential of the primary agricultural soils caused by the development or subdivision. And I think that's important because this statutory framework requires not only primarily that the applicant avoid primary ag soils. If the applicant's not able to avoid primary ag soils, the applicant's then required to both minimize and also still mitigate for all of the impact that the applicant might have on primary ag soils, which I think is a different test than what has been proposed in 6.1. So the proposed criteria, 6086A1B, which is greenhouse gas emissions. This one I don't believe was changed in its current version.
So just to rewind, ours has an or, is that what you're saying?
Yeah.
6.0?
Yeah, 6.1 has an or, and I don't think greenhouse gases was changed in 7.1. I think it was only the second two, forest and connected habitat. Other than the or, it's relatively similar. So we have avoid, minimize, and mitigate. Avoid the emissions of greenhouse gases, including greenhouse gases from the vehicular traffic to be generated by the development or subdivision. If it is not feasible to avoid such emissions, we'll minimize them, or finally mitigate. And the mitigation requirement is set up so that the Natural Resources Board will develop rules on how that works. So it's hard to sort of theorize how that might look at the end of the day. But I can imagine it being an interesting process coming up with rules on how to mitigate. There's also an issue with respect to minimize. At what and these are issues, I guess, that were eventually addressed they were addressed to a certain extent in the prime ag discussion, but I think it's less relevant there because ultimately there's that mitigation requirement regardless of how much has been avoided or minimized. I guess my concern here with this particular setup in the greenhouse gas emissions is what does minimized look like, and when is minimizing satisfactory? So it's something that either the legislature and or the Natural Resources Board with input from A&R is ultimately going to have to wrestle with, and I can see that being an issue at some point.
Representative Dolan.
I'm really intrigued by that point, because if we can create an incentive to minimize and avoid the mitigate part, I think we're better off. You know, if we're doing what we can in this case to maybe through efficiency, energy efficiency, to be as weatherized and efficient with our energy use, we could incentivize the achievement of those objectives as opposed to simply mitigating and not taking the necessary steps to try to achieve them. Is that how we could structure it? Is it incentive-based?
I'd imagine that that's certainly something that can be done legally through statute. I'm not an expert on greenhouse gas emissions, so I don't think I'm the right person to ask whether or not something like that would achieve your goals. I think legally we'd be able to do it. I just don't know whether or not it achieves your goals.
Okay. But the or, I think, eliminates the opportunity for an incentive-based, in my mind, to encourage that maximization of a minimization approach. Thank you.
I'm there with you.
Thank you.
Well, then there's the avoid as well, which I think is difficult in the context of greenhouse gas emissions. Again, I'm not an expert in greenhouse gas emissions, but I'm having a hard time sort of understanding how a project would completely avoid greenhouse gas emissions. There's got to be some impact. You know, maybe in an ideal world that impact's going to be relatively small, but avoiding any emissions, I think, is going to be quite a task in the first instance. So the proposed criteria 80, 86, A, 8, B, and C are the new proposed criteria for forest blocks and connecting habitat. They follow a similar approach as the greenhouse gas emission criteria. There's the committee has provided some more legislative guidance on these two issues as to how to minimize a project. If you're interested in reviewing, they're at page 40 and 41. It basically says build as far away from the block or the habitat as possible, cluster do as a good a job as you can to cluster buildings. Those types of planning tools are recommended for methods to minimize either fragmentation of forest blocks or connecting habitat. Again, 6.1 set up a mitigation process in 10 VSA 6094, which in many ways parallels the current mitigation process for primary agricultural soils in which is at 6093 currently. And it also deferred to the Natural Resources Board to come up with rules. But so far, it's still in the theme of forest blocks and connecting habitat. In some ways, it's similar to the current 8A necessary wildlife habitat, though not precisely the same. It's got some similarities in that it requires, to a certain degree, an avoidance and minimization, but with no express statutory requirement to mitigate. And I just I'll point to the fact that in many instances, though criteria 8.8 necessary wildlife habitat does in itself articulate mitigation as an answer to comply with 8A, in fact, that's the way that the process has worked in a number of circumstances. The Agency of Natural Resources has mitigation guidelines for wildlife. They are often a party, if not always a party, when there is an issue with necessary wildlife habitat, and they have guidelines for deer. I think they do for bear as well. Someone Billy's over here. I don't know if there are other animals that have specific guidelines other than deer and deer.
We're developing them for threatened and endangered bats, but other species we just deal with on a case-by-case basis.
So, in fact, we end up with de facto mitigation, though it's not specifically articulated or enumerated as a way to deal with these kinds of impacts.
Representative McCullough.
Well, I would say first that I would think it'd be pretty hard not to find some ways to minimize in forest blocks or connected habitat. But if the person was not able to find a way, just not able to find a way, it would be my expectation that game over. And I would be very disappointed if A&R goes, but wait, this is really a lot like what we're doing, as you just, and gave them a way to do that. And I think there'd be an interesting headbutting situation going on here. And so, how do we minimize that one before it happens?
You ask a good question, and I don't know that I have an answer for you right here, unless if the committee was absolutely dead set against any form of mitigation, I'd imagine that you could probably make that more explicit in the statutory language.
Yeah. Thank you.
And of course, that's a policy issue that.
Yep.
Representative LaFave.
I was just going to comment. I'm very strongly opposed to removing mitigation as one of the options of the three, and I think all I have to do is take a look at the area where I'm from, which is Essex County in particular is over 90% forested. Orleans and Caledonia counties are very close, and any projects that are going on there are going to, very possibly, most probably, impact a forest block. See how it's going to avoid it. And if they can't mitigate these projects, I fear the economic restrictions is far too great in an area that's already dramatically undeveloped.
Yeah. Well, I guess assuming for a moment we take your scenario and the statute remains as the current proposed 7.1, there still would be the opportunity to minimize. Again, though, my concern as someone who's gonna be implementing this language eventually is what does minimize ultimately look like? And how do we know whether or not something's been minimized sufficiently? And that's just gonna be a problem of interpretation. Maybe there's some statutory answers. I don't have one right now to offer.
Representative.
Perhaps when you talk about needing legislative guidance on the forest fragmentation, what we had discussed earlier with respect to greenhouse gases is to really defer to a rulemaking process so that it would provide an opportunity for experts to be able to craft, and public input to be able to craft the appropriate rule to meet those that avoid, mitigate, minimize, mitigate. Perhaps that could be a mechanism with respect to forest fragmentation, and I wanted you to comment about that as an approach to try to seek more of that guidance
Yeah.
in terms of defining how to best comply.
Yeah, well, I think that is a possibility. It would be, I can imagine, a very, not an impossible task, but it would be a difficult task, especially in the public setting, taking testimony from all the stakeholders involved. It's certainly something that can be done. I can imagine it being a difficult task to get through, though, with respect to the rulemaking proceedings.
Thank you very much.
Absolutely. And if there are any follow-up questions, just let me know.
All right, looks like we have Chris Cochran and Kate McCarthy. Are you presenting together? No, we have Chris Cochran. Welcome, Chris.
Together but apart. How's that?
That's a country song.
What? Nope. Oh, that's good.
Yeah.
Yeah.
Fresh air.
All right, home stretch, right? Great to see you all again. Chris Cochran from the Department of Housing and Community Development. I do have pretty pictures. Sorry, Greg. No. I'm here today to talk about some interstate design guidelines that the department did back in 2004. These don't have mold, I promise, but they are kind of old. So I'm going to just give a quick overview of kind of what we did and then provide a few case studies for you guys to consider. And then Kate is going to follow up with kind of nitty-gritty details about how these design guidelines could be applied, presumably in an Act 250 scenario. Quickly, we all know that interstate construction dramatically changed Vermont's landscape and our economy. Arguably, I-89 and 91 are probably the most important roads in the state. They're really expensive, and they were very expensive to build, and they're very expensive to maintain. And so poor planning on the interstate network that causes congestion or backups is really an important issue. I think I challenge you to look at the interstate system as like a limited resource.
Representative Terry.
You're talking about Vermont?
Mm-hmm.
You have traffic problems in Vermont on our interstate?
Off the exits, absolutely, yeah, we do.
Jeez, I don't see that in Ronald County. You know? And I travel all over the state.
No interstates, although I would argue Route 7 is close. But.
Yeah. But where these interchange, where you exit, and how the projects are planned and developed around there can cause congestion. I've been to Chittenden County multiple times and seen the road back up quite considerably. So while you
need more interstates in the state. Is what we need.
Well, I'm not here to talk about that, with all due respect. So, but poorly planned interchange areas can diminish this resource, which is limited. We're not making any new. And, think of it like a wetland. There's not like they're making more of this. They're not making more ag soils. They're not making arguably any more interstates. And widening the roads are not necessarily the answer. If there was, we'd all move to California. But our interstates are a tremendous asset to the state. This is a picture from Fairleigh, Vermont. Some of you can see. I'm sorry, not all. Maybe you all can see. It is beautiful. It helps showcase and market our state to our visitors. My wife lives in Boston, and when we come back from there, if there's something nice about crossing the border from New Hampshire to Vermont, something is different, and maybe it's just me, but I feel something is different. Maybe it's just I'm getting closer to home. But arguably, our interstates were designed differently. We took our billboard law is the big difference from most of the other 50 states. We don't have those littering our landscape. We've got some really interesting art along the interstate. I don't know if you guys have seen that. You probably know the story. These used to be in Randolph, but were moved to Williston. Yeah. I know. I love the irony of that. But apparently they found some whalebone somewhere, so they were here at some time. We, are a tourism-based state, and that's why we spend a lot of money on our visitor centers. They're very well planned. They're very well designed. Often when I go to a visitor center in another state, I find them inferior to what we have in Vermont. So it really is an important resource, because we are a tourist-based state. It is an important, huge contributor to our economy, and most of our visitors come to Vermont via the interstate. Less pretty things that we do need are, places for trucks to get fuel, like it or not. Most of everything we get comes on a truck. Some comes on rail, but most of it is via trucking. So you need to plan for facilities for trucking.
But even the trucks are nice, they're all like brand new.
Yeah.
Where are those trucks from? Those Vermont trucks.
Yeah.
Check the number plates there.
Put some mud on
Washed
those
all the
trucks.
dirt off.
I was trying to, make it look nice. These are not the worst things. But interestingly, and this is for you, Representative McCullough. This is, way before my time. This is a picture from 1975, but this is Taft's Corners, 1975. This was planned as a trucking distribution area back in the day because it was close to Chitney County. It's close to a population. There was available land. It was flat. But and these areas are incredibly valuable because of the access they provide to. So the real estate is very expensive. But how these areas get developed needs to be carefully planned.
I know those farmers that own the barns, they're gone now. but
Yeah.
Barns and the farmers.
Wasn't that Rowley?
Uh-huh.
Was it a Rowley?
Yep,
That's
the
Rowley.
first one,
Yeah.
yep,
Oh.
and Blair after that.
But how these places get developed is important because we do also spend a lot of money investing in our downtowns and our village centers, and the development potential of the interstate, if it's a lot of commercial or retail use, has the potential to kind of draw the like out of the villages and downtowns we're trying to support. So it is important. It does matter. I would say how you get the development you want in the state is really a team sport. We all kind of, pardon the metaphor, need to be rowing together from a state policy level, from a regional planning level, and from a local policy level. If we want to get the types of development that we want on the interstate. And that was the background to why the department did these guidelines back in 2004. Well, really the nexus of the seed was Howard Dean. Governor Dean, there was a proposal to develop on exit 17 in Colchester. It was the scenic part of the interstate where you go off to the islands. You do not want to see development here. This was back in 1998. He got in the middle of it. He said, we do not want to see this happen. And he basically he worked out a deal for this land to be bought and conserved. So easements were placed on it. But the reality is we can't do that. We have 52 interstate interchanges in the state. That's not the solution that we can apply statewide. So it wasn't realistic. So Governor Dean asked the department, and again, this is way before my time, to do a quick analysis of the interstates exits in the state. There are 52 of them. The department and their consultant did a quick analysis of the interchanges, the typology, kind of what kind of development was around there, the development pressures. They photographed and documented all these interchanges. Somebody 100 years from now will be interested to come back and look at these things. But what they did is they ranked certain parts of the state for high priority. We're seeing some development pressures and that would benefit from these design guidelines. department developed these design guidelines. Kate's gonna talk to you more about them, I'm presuming, in her presentation. But it basically falls into two sections. One is, the basic planning considerations. What's there, what are your constraints, what are your opportunities? And then the latter part of the book talks about the design guidelines themselves. So if you're gonna build something here, what are your options? How do you build the site out? And a quick example of, kind of what the guidelines did, there was various typologies for different types of development. This is I-89 in Middlesex. And they did an analysis of what the current zoning back in the day would allow, and what it would presumed, what it allowed at the time was industrial park development. So single-story buildings, large lots, not shared access, lot of pavement. And that's what the zoning allowed. So they said, if this were to happen, this was the kind of development that we see here. And what the consultant did was say, are there opportunities? Can we do this better? Can we apply some smart growth thinking to some of this development? And we want the development to be there, but can we pull it together? Can we make it more compact? Can we use it? Can the development use shared access? Can there be mixed uses? Can we have housing next to where businesses are located? Can we share parking? So that was the goal of these guidelines. And again, there's different typologies for various different build-out scenarios. And I would say, these guidelines were written to help communities and regional planning commissions do the research and analysis to come up with the plans and bylaws to shape this development the way they wanted to see it happen. They were not meant for regulatory purposes. A lot of this is aspirational, frankly. Unless you have the rules in place to make sure the development happens, it's just not gonna happen. You need to plan for these types of developments, and it's hard for Act 250 that looks at one project and not the larger context to kind of get that kind of development. But quickly, the design guidelines were useful. Here's some quick examples. I don't know if you may be familiar with these cases. One of the regions, Two Rivers, Ottaquiche region, Peter Gregory did use the state's guidelines and pulled them into the regional plan. And they played an important part in this exit 1 case, Quechee Highlands development. This was a case where the municipality supported kind of a mixed-use development off the interstate. The Regional Planning Commission opposed it. It went to Act 250. It was appealed. Went to environmental court. Environmental court told the commission to issue a permit. That was appealed. It went to the Supreme Court. Ultimately, the Supreme Court reversed this decision. So here's a good example of how the design guidelines were being used to influence and shape a development that shouldn't have happened in this location. Another example, more recently, that we maybe are more familiar with was Exit 4 in Randolph. I don't know if you've been to downtown Randolph recently, but it's pretty fragile. They've got a lot of vacant buildings. They really could use some help. Arguably, building a lot of more development on the interstate would not be a big help to the downtown. This was an important scenic view. That's the initial scenery you saw at Whale Hills back in the day. So advocates got together and through the Act 250 process was able to purchase and conserve this parcel. So these are a couple examples of how Act 250 can be effective in shaping the development we want in and around these interchanges. I think the nice part of the story is just this year, I think the Vermont Community Foundation paid to reinstall a different set of whale tails. So now we have 2 sets of whale tails in Vermont. These ones I think are bronze and the other ones are stone. And I'm wrapping up. I think nobody wants ugly and bad development in and around the interstate interchanges, and I support the committee's goal to do that. I guess the point I made earlier that the design guidelines, you really need to focus on the planning and the framework to get the development you want, and I think it'd be hard to apply the design guidelines to the Act 250 criteria and make that work. If the goal is to improve the designs of these areas and make sure that we get the development we want, it's really, I think the best strategy you could consider is more investment in local and regional planning. to ensure the communities do this work, and so when they are reviewed in Act 250, it can be considered in criterion 10, and that's the way to actually really more effectively design the changes that you'd like to see. That is all I have.
Can you speak for a second on the conflict between, at the exit one, the town, you said the town plan called for mixed-use development, but the regional plan didn't.
Yeah.
And there was the, and we've talked, help me out. What's your solution there?
Sure. Reports.
Yeah.
Davis, you should talk to Peter Gregory. He can give you a lot of facts on this case.
But if it, I guess I'm pushing you a little because it's a regional, you've made a great case for why these are a statewide resource. And not sure about reconciling.
I don't know the best way. Well, I don't know if the design guidelines are the best way to protect them. If they're going to really get you the result that you want.
But they did under executive order for a long time.
There's been no executive order for a long, long time, and I just don't see a hold on any development happening. I think that's, in reality, my opinion, Middlesex, that example, I don't think anything's been built since this was done in 2004. If there has, it's been very little development. So I don't know what the executive order, what powers that would bring, or how that would shape future development. I do think if you want compact development, if you want these things, it needs to be done comprehensively, and it's really hard to have a permitting program that looks at one parcel, really design a network of streets, or indicate the kind of design standards you want. That kind of specificity is really more appropriate in local regulations. And if that's what you want to do, I mean, I think everybody would agree that nobody wants ugly buildings and inappropriate development along the interstate. While that process is harder, I think that's
I have a quick question. What is 7 from Dorset south and then the 279 road? What is that all considered? Is that interstate? Is it just one big interchange that's 40 miles or?
It's called Super 7 is the word I heard. It was a widened road. It's a state highway. It's not an interstate. But the types of approaches, how these arterials get developed, the basic concepts are the same.
So the interchange issue you're talking about would apply down south then, off these widened roads?
I don't know. I think in your definition it says interstate interchanges, and that's a 3,000-foot radius from an interstate interchange. I don't know how you define interstate interchange. If it's just federal highway or federal and state highway.
Have you seen it ever? Have you been down there?
Oh, yeah.
So it looks like a interstate,
Yep.
but it's not considered one?
Yep.
Okay. I got it.
But it's really how you define it, what kind of jurisdiction you capture.
Okay.
So super quick, I hope that helped.
Representative McCullough.
Yes, well, it does help. It reinforces that certain bodies of work that got done, we shouldn't use for purposes of regulation, such as mapping, e-mapping, and so on, and now we're getting this advisory as well. How might we use this work in Act 250 to help our town and regional planning come out with a conclusion that protects, in your words, what we all want to see?
Well, through criterion 10, Act 250 has its criteria. One of them is to look to the local town plan, and does it meet those requirements? So if there's specific standards in there that the project's not meeting, it wouldn't meet that criteria. I think that's the best way. In theory, I think this is good ground-based work. If you wanted to apply it in an Act 250 scenario, I think a whole lot more work would need to be done to make sure that they were in harmony with the other criteria. There's transportation criteria, there's aesthetics criteria, there's 9L settlement criteria, and applying those criteria and then applying an overlay of design over the top could be challenging. And we haven't explored what that would look like, but it's conceivable, but it would just take somebody's time and money.
Only note that a bunch of the dots on your map that qualify, are on fire or fire. Very, very important to deal with and least important to be concerned about. Those dots are all over the place and many are in towns that don't have plans for Act 250 to take notice from. And so how does this idea balance out with what we just told?
Well, I mean, if you look at those two cases, Randolph probably didn't have the most, robust regulations, but Act 250 was triggered, and got a solution that everybody seemed to be happy with. I'm sure some people in town disagreed with the decision. The question you always have is jurisdiction, It has to be a large project to actually trigger, the jurisdiction. So this looks at location again to trigger your jurisdiction. So you're saying any project within this radius would trigger. So it's conceivably would be helpful for those towns that have nothing. Often the towns that have nothing don't have any development pressure, so they just don't feel the need to have zoning regulations. But I haven't done any additional analysis on all the exits and where they are. And I think the goal is good. I don't know if this is the right approach.
Thank you.
Thank you very much, Chris. And Kate.
I'm Kate McCarthy. I'm with the Sustainable Communities Program Director at the Vermont Natural Resources Council. And glad to see the whale tails here. They are coming back. Stay tuned. Spring 2019 at Exit 4. And it's the same artist as the original whale tails, a fellow named Jim Sardonis. It's going to be a really nice addition to Exit 4.
They should put the heads.
Pick another exit.
Yeah.
Get to work. As you
We've
know,
got 50 more exits to go. Yeah.
A lot of whales. So I'm a land use planner, and my work at the NRC focuses on a lot of the things that you heard discussed already today, promoting downtowns and villages, making sure we don't sprawl and use land inefficiently, because that can lead to real pressures on the things that we invest in, our road system, our downtowns, and our interchanges, especially because of the high development, because there is development pressure there. VNRC's been involved in issues related to interchange for decades. I haven't quite hit my first decade at VNRC yet, but I've been involved a lot as well, including with the Exit 4 project that you saw featured. So I'm going to talk about the proposal that you have before you. Before I do, I want to reinforce why interchanges matter and why now is a good time to be thinking about it, and then what the bill proposes and a little about how it would work. One either preview or spoiler that I want to share is that I do believe that these guidelines are suitable for use with updating in regulatory review. The planning piece is essential, but if you do decide as a committee and as a legislature that these are resources of state importance, then I think it is appropriate to manage them as such through a statewide review process rather than leaving it to a case-by-case, town-by-town approach. More on that later. So, as you've heard, these interchanges are gateways to many of our communities. Maybe it sounds a little silly to be thinking of a big highway as an entry point, but in reality they are. They're part of the look and feel that support our tourist economy, and it can impact our downtowns and villages. You've heard that. I want you to hear it again because it really does matter. There are a couple other values that I think are very important to highlight about interchanges too, and show why interchanges rise to the level of being a state resource that you should review under Act 250. And one is rather mundane, and that is ensuring a safe and efficient road system. Interstate interchanges and the roads near them are meant to move traffic to and from the interstate. And with every new driveway that is put next to that, that function is undermined. It can lead to many more lanes. It can lead to more turning, which can lead to safety issues. It is unfortunately too easy to use Williston, Representative McCullough, as an example. But if you head toward Taft Corners, think about how wide that road is and how tricky it is to get out of that gas station, or how difficult it is for the state police barracks to even operate their basic function. Right now, the state is in the process of spending multiple millions of dollars to relocate that barracks because the road function has been so undermined. If we think ahead about land use planning, we can save ourselves some money. Also kind of in the infrastructure category, development at interchanges can put pressure on communities to extend their sewer or water to serve those areas. And since uses near interchanges tend to be more spread out, you've got fewer users per mile. That means you're providing more infrastructure with fewer people paying in, and we have limited state dollars. When we know that, given that we have limited state dollars and increasing needs, it doesn't make sense to knowingly develop land in ways that cost a lot of money in the long run. So these are all things we've known since 2002, or 2001 when the executive order went into place, 2004 when these guidelines were published, and frankly, many, many years beforehand because it's basic math. So why are we taking action now? Part of it is we're having this big comprehensive conversation about Act 250. So as we think about the most appropriate locations for Act 250 jurisdiction, it makes sense that we would think, just as you're contemplating critical resource areas and downtowns, to contemplate other resources of state importance, and interchanges are one of them. Also, we don't have rampant development at interchanges, but we've seen things warming up. You heard about Exit 1, Quechee Highlands. You heard about Exit 4. One of the things I want to say about Exit 4 is that was 1.15 million square feet of development on 150 acres. So it was a big project that was spread out over the land, and design would have made a difference there. Those are the dramatic ones. We've also seen more pressure from small box development, not the big box that made the media so much in the 90s and 2000s, but the smaller boxes. And what I'm thinking of are things like auto parts stores or dollar stores or Tractor Supply, things that may be useful, but that also tend to locate in sprawl locations. We've gone from having $14 stores in Vermont in 2007 to 58 in 2017, and 60% of those, by my calculations, are in sprawl locations. So that's the type of scale of development we're seeing, which makes highway interchanges pretty appealing. I think we need to pay attention to that. So next I'd like to review what the bill you have before you proposes. I'm sure that you have looked at it, maybe discussed it a little, but I'll just recap it for you. First, it updates Act 250's jurisdiction so that all development within 3,000 feet of a highway interchange becomes subject to Act 250. And you'll find this on page 7 of draft 7.1. The definition of interchange is on page 13. And to Representative Bates's question, you want to probably clarify which roads are considered the major roads that would be subject to this. It might just be 89, 91, and 93. So then, once this jurisdiction is created, it creates a criterion I to review that development, page 42 and 43 of your draft bill. And what that criterion calls for is it calls for development to comply with the interchange guidelines that you've been hearing about. In addition, criterion I gives regional planning commissions a task. It says, look at the interchanges in your region and identify what they're like. What type of interchanges do you have in your region? Because not all interchanges are, Brattleboro and Bethel are very different. You've got different types in different parts of the state, and those serve different functions. Some are very close to downtown, some are mostly commercial type services, traveler services. We'll talk a little bit more about that in a minute. But what I think is really important to highlight there is that when you say you're going to apply guidelines in Act 250, we're not talking about having the same guidelines applied to every single interchange throughout the state. The guidelines that would get applied would depend on the context. And that way you're not calling for one size fits all, and you are recognizing that these interchanges do have traveler service functions, and they have a variety of functions that may be appropriate. Okay. So, about the design guidelines, the first thing I want to say is that, I don't think, this is the book, this is what it looks like. You may hear design guidelines and think this is about making everything look like a barn, so it's cute, This isn't about aesthetics. It's partly about aesthetics, but it's also about how a site functions, how safely people can come and go from the site, how the one site connects to the sites around it, and how the flow within the site works. So design is a lot of things. It's about the way the site is laid out, as well as about the way the site appears and relates to its surroundings. And as Chris said, the guidelines were developed based on research to ensure that they didn't ultimately come up with just one-size-fits-all recommendations for all 52 of these. Those were called typologies. And I want to, this is perhaps all feeling a bit abstract, so I want to show you what those typologies are, turning to page 20 of the design guidelines. So they're cleverly named. There's A, B, C, D, and E. I won't read through them, but you may find it interesting to look at on your own. Type A is nearby, a typology of an interchange that's nearby a downtown or village, less than 1.5 miles between the interchange and the village. So examples are Barton, Orleans, Montpelier. Those are maybe three that are pretty easy to visualize. Putney is another one, pretty close. The second typology is a new or emerging growth center. The village or downtown might be close to the highway, but not easily expanded, so it might not actually become a part of the whatever development happens at the interchange. So the Middlesex example that we saw from Chris is an example of that, where the village is nearby, but not exactly one you can expand with the highway. Think Red Hen Bakery village area, and down the street from there. Type C, a regional arterial highway that could end up being strip development. This is one, Waterbury is an example. It's where the highway is a regional corridor that connects to a town center, and as a result, there's space that could end up being strip development. But there are also opportunities for infill. I used to live in Brattleboro, and there are 3 highway interchanges in Brattleboro, and 2 brings you up down Route 9 right into the village, into downtown. But 1 and 3 are kind of strip development areas with some older big box development. That's what's there now, but there's a lot of opportunity to make it better, and some of that's already happening, kind of filling in the blanks where there are parking lots or empty lots. And that can then become a strong and attractive and economically viable part of the community. Last couple. Connector Road. The examples here are Hartford, Rockingham, and Weathersfield, where the town is more than 1.5 miles away, and so there may be a real temptation to put a lot of things at the highway. And then it's also important to acknowledge Type E, the rural interstate related functions, where it may be appropriate to have a truck stop or a warehouse or other services related to that type of commerce. And Springfield is an example of a Type E rural related. And then limited access highways, you can't access the land, so it's not under development pressure. I would like to do a time check with the vice chair and ask what time I should conclude.
How much longer do you anticipate?
5 to 8 minutes for the presentation.
Let's go for it.
Thank you. All right. So those are the typologies. Oh, excuse me. Again, it sets it up so that we can think about context and appropriate development. All right. So then, based on these typologies, it's actually A through F. This guide goes on to provide examples of how you would design the site so that it achieves, for example, a gas station is going to be different at an interchange near a village or downtown than it's going to be if it's in a rural area. It's mostly about trucking related uses. So I just want to give, when I'm talking about guidelines, I want to give you an example of what I mean. So I'm going to page 27. And to talk a little bit here about access management. So what this means is, how do driveways go onto the intersecting road? A lot of times you might be at a business that has 3 driveways that are each 30 feet wide. I'm exaggerating a little bit, but I think we can all think of businesses that have many access points onto the street. It may not lead to the safest flow of traffic in the area. So the best example here, the access, right here, one way that you, in any interchange type, is that you would make access safer is that you would consolidate curb cuts. So in this picture, instead of having one curb cut for each business, you might arrange the buildings, cluster the buildings so you can share a curb cut, share parking, and have fewer cars coming out onto the road at multiple points. So that's an example of just a general thing you could do. And then this guide goes on to say, you might point out how you would do different things at different types of interchanges. So for example, for those interchange types that are closer to existing settlements and villages, you would allow at least 250 feet between the interstate entrance and exit ramps and adjacent curb cuts, whereas in the other types of roads, you'd allow 500 feet. Seems like a small thing, but it helps the flow, it helps the safety, and it helps preserve the underlying transportation infrastructure. Nearer to a downtown, you might have a plan for public transit and bicycles. You might do something different for parking than you would at an area not as close to a downtown or village. So these are some ways that the site itself, based on the typology, could be designed to make everything safer and look better too. Okay? So it's always more interesting to have real examples. So I'm gonna continue what Chris started, showing you the example from Middlesex and show you a different one. And these are all in this book, you can look at them. So this is type A, nearby a village or downtown, and this is Barnett. So there you have it. This is the existing condition. And then this next picture, with the addition of these buildings right in the middle, shows a pretty typical way that development occurs. This is standard, it's easy to finance, it's something people are familiar with. You can also see that it's quite land consumptive and paves a lot of land. If design guidelines were implemented and followed, this same land, I'm sorry, what this gives us is 57,000 square feet of industrial and commercial. With design guidelines, another way you could approach it is like this last picture, where you've got some shared parking, you've got one access, you preserve more of the field, and what this gets you is 61,000 square feet of industrial commercial plus 13 to 17 units of residential. And so it's the design of the site that you get the same thing, you just do it in a different way on the land. You put blocks together in a different way to achieve a different form.
You said easy to finance. Is there any way to work with people who are offering financing to incentivize or disincentivize how financing is offered depending upon the quality of the development?
That's my dream come true. No, I don't know I don't know what those levers are in particular. I would need to do some research into that, but I do know that it is complicated because lending plugs into just a lot of things that are beyond Vermont in scale.
They would partly be based on the appraisal, so maybe appraisers would have to.
I think sometimes, that's the case sometimes with energy efficient buildings, that appraisers are coming to learn better how to value one of those buildings so that you can get the right amount of insurance or so that you can get a fair resale value. There could be some related things there. Some of that work's been done with brownfields properties, so yeah, I think that's a piece of the puzzle.
I have a question for you. So, the way Act 50 stands now, let's say that a project like this is planned, and you are, you represent the state, or you represent the stakeholder in terms of the VNRC. You come in and make a presentation in terms of showing slides like this is a more reasonable or rational use of space so that we have some green space as well as a commercial development. Isn't that the way it's now happening, isn't the way the commission now comes to grips with these kinds of questions? Is that they hear your testimony, see your drafts, and whether or not they choose to go in your direction, they don't or do?
That is sometimes how the process unfolds, that a project's design will be modified based on stakeholder input. There are two differences. One, with guidelines like this in place, then an applicant doesn't have to keep going back to the drawing board. The first product can be the one that is going to have less of an impact, the first design. And the other thing is that in the current process, there aren't guidelines against which the district commission can evaluate the project in quite this way. So in the current process, the back and forth may lead to the commission saying, well, that is a nice revised design, but the original design meets the criteria well enough. You have your permit. Whereas if these were in place, I anticipate that the commission could say, I don't believe that criterion 9I has been met because the guidelines have not been followed.
Thank you.
Okay. I'll give one more example because pictures make it more interesting. And this is an example from the town of Richmond, 25. So this is considered a connector road, and sorry it's a bit granular here, but you see the empty space kind of in the front, the southeast quadrant of the top diagram, and then if we go to the second, you can see how that might be developed. So again, you've got those multiple curb cuts, you've got buildings with their own parking, and in this hypothetical example, you've got 48,000 square feet of commercial and 16 units of residential. If you were to apply guidelines to use the space more efficiently, you end up with 40,000 square feet of commercial, a little less, but 16 units of residential, and you've left available a lot of additional space either for future development or for other uses. The Richmond example is very interesting to me because it's more than theoretical. In 2015, I got a phone call from a concerned citizen. Richmond was looking to extend its sewer and water lines right along this road to serve a mobile home park with a failing system, which is a perfectly good use of a sewer line extension because it's public health and safety and affordability. At the same time, though, they were also proposing changes to their zoning that would make it easier to develop like this. And so that's an example of how when you extend a sewer and water line, there can really be pressure to add more, to do that. And if you don't have the right sort of zoning in place, it can really lead to some unfortunate land use outcomes.
May I ask a question?
Sure.
But can you achieve your objective here without sewer and water because of the concentrated development to service these residential units?
So with 16 units, I think that there could be like a shared community system of some sort if there's land available for that, and to park and for the septic tank. Yeah. So getting back to the preview that I gave you earlier, you've heard that these are not ready for, these guidelines are not ready for use by district commissions, but I wanted to add a little bit of history. They were originally developed for the purpose of guiding regulatory review, and my source on this is my executive director, Brian Shoup, who was a planning consultant at the time and hired to do the guidelines. And that was during, actually I think Chris and I are both right, and you're gonna hear why. So Brian was hired to do this during Governor Dean's administration. The guidelines were completed with the pieces and parts that I have just shown to you, but it was not released. Then there was a change in administration. Governor Douglas took office, at which point there was language added saying these were not intended for regulatory review. So take that for what it's worth, grain of salt. I think regardless, there was intention behind this for it to be used to guide regulatory review. I also think that it would be worth updating and improving them so that they could be very easily used by district commissioners and by applicants, because we don't want something vague. We want something that's gonna help people develop in a predictable way that saves them time and money. So, I believe these provide a fairly good amount of guidance, but they could be made more usable. When we've had criterion changes in the past, there's been accompanying guidance developed, and I think that could be the case here. That seems reasonable. There's just one addition I would suggest if you decide to go forward with this, which I hope you will. Criterion 9I sort of hints at the regional planning commissions designating these typologies, but you could make that clearer if you were to update the part of statute that says what goes in a regional plan, and that's 24 VSA 4348A, elements of a regional plan. Just add it to the list, and then it becomes embedded.
Gary?
Can you clarify that? What could be added to it?
Sure. So right now, the way that regional planning commissions are told that they should identify these typologies is within criterion 9I itself. But regional planning commissions don't turn to Act 250 or other parts of statute for their marching orders. They look at the section, the enabling section for RPCs, which is in Chapter 117. So within Chapter 117, there's a list that says what a regional plan should include. And you could add to that list that a regional plan's land use section shall include the delineation of interchange areas in the region according to the typologies as contained in the guidelines. Does that make sense?
If we did that, wouldn't we be taken away from the governance of the regional commission?
Taking away from the
Isn't
governance?
it their decision and within their area in terms of how they want that area to appear and basically the testimony they get from the communities in which they represent, it seems like something's coming down from the top.
That's one way to look at it, but I think the way that the typologies are developed is based a lot on existing conditions, what's already there on the ground, rather than just what should be there in the future. So it's built on the existing context, the same way that if you do a plan, you would do one thing if you had a steep mountain valley and another thing if you had a big, a flat river valley. So it does prescribe that these typologies be used, but those typologies were built based on what was there already, so.
So it seems very prescriptive to me.
Okay, I hear you. I think that the RPC could look at it and say, I think it's this typology and not that one, and then you and I could have a discussion about why it's D versus C, for example. Yeah. We could make a C.5.
Any more questions for Kate? Well, appreciate you coming in.
Yeah, thank you very much for your time here at the end of the day.
I don't know what the chair has in mind, but I'm just about OD'd on Act 250 for the day.
I second the motion.
So I would accept the motion that we adjourn for the day and come back to another.
I will make that motion.
Okay, so thank you all for coming in and bearing with us.
Thank you.